Okay, this is going to be legal issues for EMS and EMS educators, and this is going to be part 1. And the topics we're going to discuss in this are going to be the hierarchy of law, areas of law, tort law, risk management, civil rights and non-discriminatory laws, and federal non-discriminatory laws. Now there's 3 parts to this chapter. Hierarchy of laws. In the American legal system, there are 3 levels of government. There's a legislative, executive, and judicial branch. Legislative creates the laws, executive enforces the laws, and judicial interprets the laws. Congress enacts laws called statutes. Executive creates regulations, which are a method of enforcing the laws, and the judicial branch interprets and applies the law in the context of the cases. Areas of law. The American legal system can be divided into 2 broad categories, criminal law and civil law. Criminal law are prosecuted generally by an attorney or attorney general. A violation of criminal laws can result in fines and imprisonment, or both. Civil law involves private matters, contracts that occurred, businesses, transactions, wills, or domestic relations. In civil cases, the injured party, or the plaintiff, seeks recovery of money or other forms of relief for an alleged act or omission. And tort law here. In tort law, a tort is a private or civil wrong or injury other than a breach of contract for which the law allows a remedy. Its act is committed by one party in either an intentional injury or negligent manner. This causes either personal or property injury or damage. In this section also we're going to talk about assault and battery, defamation, misrepresentation or fraud, negligence, and defenses to negligence. So, assault and battery. Assaults occur when one person places another person in reasonable fear of immediate harm or physical contact. So the assault is just nothing more than the fear of that contact. Battery is the physical unlawful touching of another person without consent. Consent is a defense to any claim for assault and battery, or battery. It's always advisable to obtain a person's consent prior to making physical contact with them. Defamation. Defamation, the intentional or reckless making of a false statement or the sharing of true but private information. An example of this that was given in the book, John Inman sued the Nevada System of Higher Education and Community College officials alleging defamation over his faculty performance evaluations. The court rejected Inman's claims on a number of grounds, but most importantly because the evaluations contained statements of opinion and not fact. As such, they could not be false. Defamation. Misrepresentation. The making of a false statement with the intent to deceive that causes actual harm to someone who reasonably relies upon it. This is pretty much a nice way of saying fraud. Example are marketing brochures that states accreditation from a certain organization when this is not the case. Someone who attends a class may have a cause of action for misrepresentation. An emerging trend in the lawsuits in schools are the amount of students who are employed upon graduation along with salaries and graduates. So falsification of information and marketing brochures of the individuals that get hired on post-graduation could definitely bring about a fraud or a misrepresentation claim. Negligence. Negligence, the failure to exercise the care that reasonably prudent person would have exercised in a similar situation that causes damages to another. Now, negligent claims must establish 4 elements. They had a legal duty, and 2, breach of that requisite standard of care. So there was a breach of that duty, and 3, there was injuries or damages that occurred, and the resulting injury or damage was caused by a breach of the standard of care. So all of those 4 things must be proved. Now, in the defense to negligence, there are 3 common defenses to negligent claims. 1 is the assumption of risk, 2 is the release of risk, and 3 is the contributory or comparative negligence. Now, in each one of those, assumption of risk, pretty much very simply that while participating in things such as EMS clinical education, that there is an assumption of certain risks, and in that assumption of risk, that would be one of the defenses to negligence. Another one, the release of risk. If you've signed a waiver form of any form or fashion, educational institutions frequently require students, parents, or guardians to sign waivers of risk form. This is done to establish the assumption of risk doctrine. The signed release form is evidence that the student was aware of and assumed the risk involved with the activity. So this is a good way on the release of risk to kind of decrease some liability upon yourself and your college. Contributory or comparative negligence. Contributory negligence was a legal theory in many states stating that the individual cannot recover from an injury if they themselves were negligent. If there was contributory negligence, individuals were completely barred from any recovery if the injury suffered was even only partially their fault. So if they contributed to or added to the negligence, then they cannot receive any type of claim to this. Risk management, and these are pretty much the methods of risk management that we're going to talk about here. Risk management is a process of preventing or at least minimizing harm or loss to a business, organization, or person. Reducing liability is the important consideration in risk management, and we should consider safety at all time. Risk management has an additional advantage: it enhances safety. So methods of risk management, there's two principles of risk management. There's risk control and risk transfer. Risk control. Safety methods are made to reduce the risk in activities or equipment that would lead to liability. Example of this, adding student supervision, emergency protocol procedures if something was to occur, and then site selection would be also a consideration in this. Risk transfer. Waivers, release of insurance policies are all forms of risk transfer. It's varying suggestions on how to reduce the risk. Safety tests and good record keeping of safety briefings throughout the curriculum. So if you gave someone a safety briefing before you took them into the lab, please document that on the date that you give it, so that you can bring back and say, yes, we did have the safety briefing here, and it clearly established. So there was some assumption of risk for the student to be in there with sharp objects. Civil rights and non-discriminatory laws. And in this section we're going to talk about federal constitution protections. U.S. Constitution, federal laws, and state laws prohibit discrimination in a variety of settings, including the workplace, public places, and educational institutions. Federal Constitution protections. The U.S. Constitution prohibits any level of government from violating the constitutional rights of an individual. Congress has enacted a law that allows persons to sue a governmental actor who violates their constitutional rights. And constitutional protections are things like search and seizure clause, due process, and equal protection clause of the 14th Amendment. Now, most of these are like search and seizure clauses, the 4th Amendment. The 4th Amendment provides the individuals have the right to be free against unreasonable search and seizures. Generally, treatment and transport are not considered custody. However, whenever we restrain a patient or do locker searches, we need to be sure that we're correct. And locker searches, even though they're for things like drugs and guns, we still need to have a policy in place so that the students are even aware of the policy. So another form, whenever the students first get into the program, that they were aware of the policy and procedure manual. So policies need to be proactive. They have no exception to privacy in locations such as a locker if you're going to do things like drugs and guns. Zero tolerance policy would need to be enacted for this if you plan on actually looking in someone's locker. Federal non-discriminatory laws, and there's several of them. American with Disabilities Act of 1990 and the Rehabilitation Act of 1973. We'll talk about that a little bit. Title VI of the Civil Rights Act of 1964. Equal Employment Opportunity Act of 1972. Pregnancy Discrimination Act of 1978. And Title IX of the Education Amendments Act of 1972 are what we're going to talk about here. So, first of all, the American with Disabilities Act of 1990 and the Rehabilitation Act of 1973. The American with Disabilities Act of 1990 and the Rehabilitation Act of 1973, no covered entity shall discriminate against a qualified individual on the basis of disability in regard to their job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, or other terms, conditions, and privileges of employment. So what this did is this kind of, you cannot, just because someone has a disability, you cannot not hire them if they are qualified for a job. Terms here are located in this act. Qualify individual with a disability, and the definition on it. This is Table 10.1. Please look over this. And comments, the term handicap has been replaced with disability. Reasonable accommodations, an interactive process involving the EMS education institution representatives and the disabled student determines student accommodations to be provided. Undue hardship, financial burden may be respected in the light of established undue hardship for the educational facility. Major life activities, to qualify for disabilities, individuals must have substantially limited activity or activities. And then substantially limited. Factors to consider in determining whether an individual is substantially limited include nature and severity of impairment, duration of impairment, and permanent or long-term impact of impairment. So none of these considerations can be taken into play without reviewing and getting legal assistance in this area whenever we're trying to make a decision like that. Title 6 of the Civil Rights Act of 1964. Let's talk about that a little bit. Title 6 of the Civil Rights Act prohibits discrimination based on race, color, or national origin by any program receiving federal funding. The law prohibits educational institutions and EMS educational programs that receive federal funding from engaging in discrimination on the basis of race, color, or national origin. Equal Employment Opportunity Act of 1972. Under Title 7 of the Civil Rights Act, it is illegal to discriminate in the hiring or terminating of employees or any other act of employment, such as EMS education programs, based on age, race, color, religion, sex, or national origin. Pregnancy Discrimination Act of 1978. Pregnant women cannot be categorically excluded and restricted from work or training programs based upon their pregnancy. The Pregnancy Discrimination Act requires educational institutions and the EMS educator program to provide to pregnant women the same accommodations they provide for other temporarily disabled workers with similar levels of incapacity. Now, educators should be aware that female students who become pregnant during their EMS education may need to delay some educational experiences, hospital or field clinicals, if recommended by an individual's physician. The ultimate decision rests upon the student and her doctor, not the educator. Title IX of the Education Amendments Act of 1972. Title IX of the Educational Amendments Act provides that the individual may not be excluded from participation in, be denied the benefits of, or be subjected to discrimination by any educational institution or clinical education program receiving federal funding on the basis of their gender. Gender discrimination cases are frequently filed under Title IX and Title VII of the Equal Employment Opportunity Act, or a combination of these two laws. And this brings us to a conclusion of Part 1. Now, if you have any questions concerning this, feel free to contact me. My name is Roy Smith, smithr@imsa.net, or 405-219-7613. Thank you.